Welcome back, everybody, to our studies in family law. In this lesson, what I want to do is spend some time talking about marriage. Specifically, we're going to spend the next 3 or 4 lessons examining the nature of marriage, its definition, and the ways in which we have explored the concept of marriage through the case law. Now, this is obviously with the view to explaining the various different alternatives that exist for marriage, and we'll get to some of the implications therein as well. Talking firstly about, of course, the concept of civil partnership and same-sex marriage, and then thinking about the ways in which marriages may come to an end, this being through nullity on the one hand and divorce on the other. But all that is in the future. For now, let's actually get to looking at the subject of marriage in more detail. Fundamentally, this is going to be something that we talked about in the previous lesson. We had a basic overview of the concept of family relationships, and this is something that we're going to really dig deep into in this lesson, exploring the concept of marriage. Like I said just a second ago, we'll spend a few lessons on the subject of marriage before looking at other forms of family relationship in more detail. So, marriage by the traditional standard is this concept of a traditional union of man and woman. That is the sort of colloquial definition of marriage, but it is one that is not necessarily supported by the case law, or not supported by law anymore, should I say, in relation to this being a traditional union of man and woman. However, at least in 1866, we see the definition of marriage as elucidated in the case of Hyde and Hyde by Lord Penzance, who suggests that marriage consists of, quote, the voluntary union for life of one man and one woman to the exclusion of others. So this idea of a man and a woman is, at least historically, a traditional understanding of what marriage entails. However, of course, there have been multiple exceptions to this in the future, but in terms of a more coherent and more legally sophisticated definition of marriage, we look here to the case of Hyde and Hyde, which tells us that marriage is the, quote, voluntary union for life of one man and one woman to the exclusion of others. So, this definition is good for a couple of reasons, okay? Firstly, it is good because it is broad, okay? It has a sense of broad elements to it. It is not limited to certain specific religions. It's not limited to certain specific practices. It is limited to certain specific characteristics and nature. Secondly, it is also able to have a certain amount of effective utility, given the fact that there are certain elements which are pertinent to this question of what marriage is. And we can simply start to unpack what those characteristics are by looking at the definition. So we have the first point is this idea of marriage being, firstly, a voluntary union. We'll get to what forced marriage and arranged marriages, how that fits into the broader conception in future lessons. But for now, you should note that marriages can only be valid if they are voluntary, if people consent to actually entering into a marriage. The second conception is this idea that it is a union for life, okay? For life. Now, again, this is something that has its exceptions because, of course, we have nullity on the one hand and we have divorce on the other, and so as a result of which you have to bear those in mind. But we'll get to that in a second. And then the third characteristic is between one man and one woman. Of course, the man and woman conception is challenged today, but the idea of it being one person and one person is relatively stable and has been for a while. And then fourthly and finally, you have, of course, the fact that this is a union for life between a man and a woman at the exclusion of others. So others are not involved in the marriage. It is a union for these two individuals. So there are problems, of course, with this definition. As noted already in the previous lesson, the man and woman element has obviously been changed and challenged by the definition of an introduction to same-sex marriage, which we will get to in future lessons' time. There is also this issue of marriage being a union, quote, for life. Of course, today, and even back then in the 1800s, the idea of for life is, of course, a tricky one, given that there are a number of remedies which seek to end people's marriages, and getting a divorce these days is very, very, very easy compared to how it used to be. For those of you who want to know about marriage nullity and marriage divorce, why don't you go and research a little bit about Henry VIII, who spent quite a lot of time trying to secure his divorce from Catherine of Aragon in order to marry Anne Boleyn. This was in the 1500s. So the concept of divorce and nullity of marriage is, of course, something that is very, very prevalent and has been since almost the entirety of the marriage system. Even in the Bible, there is various exceptions to marriage, which allows for there to be a divorce procedure and a nullification of a marriage as well. So it is obviously this idea of union for life has always stood on tricky ground. We will get to what this means in future lessons, though. But now I want to just spend a little bit of time talking about the concept of marriage being voluntary, marriage being the, quote, voluntary union of man and woman. This is one of the most fundamental elements of marriage. Not historically fundamental, but at least one of the most fundamental today. Characteristics of marriage is this idea that a marriage has to be voluntary. You can't involuntarily get married to an individual. You have to consent to it, otherwise that marriage is null and void. All parties, in order for a marriage to be valid, must consent to their union in order for it to have this validity attached to it. If not, then it is void and is unable to be essentially enforced. The legal characteristics of an involuntary marriage is that they are void and they have no meaning. The next lesson we'll spend some time talking about how the law protects against forced marriage and protects victims of forced marriage and from forced marriage. Fundamentally, forced marriage is something that still exists in various different parts of the world and in various different parts of the United Kingdom, specifically when it comes to things related to, for example, human trafficking, and when it comes to things like sex trafficking. Of course, these are criminal acts in and of themselves, but so too is the attempts to acquire a forced marriage of an individual. It should be noted, however, that there is the protection of an individual from forced marriage that is enshrined both in domestic legal jurisdiction as well as in international law. At least as a human right, the freedom of marriage and the freedom from forced marriage is something that has been protected ever since the Universal Declaration. Now, it should be noted, of course, that the Universal Declaration on Human Rights is not a legally binding instrument. It is something that is represented as what we call soft law. However, of course, a lot of human rights treaties and provisions have actually included this into their particular legally binding documents. But Article 16 of the Universal Declaration says, quote, "Marriage shall be entered into only with free and full consent of the intending spouses." So it is clearly defined in one of the most fundamental human rights documents that marriage should not be done without consent. While, like I said, the UDHR is not a legally binding instrument, a number of its provisions have been further codified into substantive treaties, like, for example, the Twin Covenants, as well as the European Convention on Human Rights. It is also just generally seen as an illustrative authority on the nature of and the protection from forced marriage in international law. One of the things that you might be wondering, however, is how this reconciles this clear prohibition on forced marriage is reconciled with this idea of arranged marriage. And this is really where we see a balancing exercise taking place, of course, because arranged marriage is actually something of a cultural tradition in certain cultures around the world, and as a result of which also in the United Kingdom. So there is the protection of people to practice this cultural tradition of arranging marriages, but also at the behest of not being able to force individuals to marry. There are cultural significances, as I mentioned, to the idea of an arranged marriage. For some parts of the world, the choice of who you marry, or at least the decision or the picking or the arranging of a marriage, is done by families. It is not done by you as a person. You don't go out to meet someone or go on Tinder or whatever and meet people. The families will pick people for you, and this is obviously something that, for those of us in the Western world who have grown up with this idea of freedom of marriage and this idea of arranged marriage being a little bit strange, you might think that it's a bit strange, but it's still a cultural tradition for some people. So often families will pick and choose the spouses who they want their children to marry. It may often be marrying into a good family, marrying into a good marrying people with good careers, etc., etc. This does not count as forced marriage, though, because it still requires the consent of the parties who are entering into the marriage. So an arranged marriage is still something that requires consent from the people who are getting married. If you have an arranged marriage situation, okay, all you are doing is arranging the people to meet and to potentially marry each other. They still have to consent to doing so in the future. Now, of course, there are instances where an arranged marriage could actually enter into the realm of forced marriage if an individual fails to consent but is still forced to do so anyway. However, for the most part, the law recognises the distinction between arranged marriages and forced marriages in the law. And that really concludes our first lesson on marriage. We've looked at what marriage is as an introduction, as defined in the case of Hyde and Hyde, as being a voluntary union for life of a man and woman at the exclusion of others. And we have talked about the various exceptions to those characteristics, as well as the concept and the protection of individuals against forced marriages in both domestic law as well as within international legal jurisdiction too.